Hi, buddies. Very good evening. I've been receiving a lot of messages from my students to discuss a case law of extreme relevance. So let's dive right into it. I'm going to discuss a very important case. We'll try to finish it as fast as possible so that I'll give you a summary of it and also give the read out the wonderful judgment and the wordings used in the judgment and also in the context of the present scenario that we are in. It is very important for us to know about this judgment. So first of all, I would thank my students to pester me literally the full evening to make this video, and because of which I had to go through this and I'm doing it for you. So first up, I went to the Rajasthan Highcourt website and I put in the relevant writ petition and I got these two cases. This is how you search. Okay, go to that relevant high court, whatever high court it is, you find the case and put it. So these two, this is Miss Risha Lodha versus Institute of Chartered Accountants of India. Yes, my dear buddies, today we are going to discuss a case law ICAI versus CA student. This is not to create some, what do you say, anything controversy as such. It's purely, for knowledge purposes. As CA students, we have a right to know about all the things that are happening concerning us as CA students, especially in the light of the COVID-19 pandemic. So let's dive right in. I have already downloaded the thing. So basically, without wasting time, let's give a summary of the entire case, what happened, facts of the case. Okay. So the petitioner, Miss Richa, is, what do you say? This lady, the person obviously who puts a case is called as the petitioner. So Miss Risha is the petitioner and the respondent will be the CA Institute. All right. So what exactly happened? So the petitioner was a CA foundation student in 2018. So she cleared it in the first attempt and her CA inter was scheduled to happen in May 2020. Fair enough, right? So obviously we know during what happened May 2020 because of the COVID-19 pandemic, the examination got cancelled. We know that, right? Then what happened? Next exam was obviously in 2020, November 2020. And again, because of the rising cases, there was an opt-out scheme, as you know. Now, during this time, it was very crazy, the scenario across India. People were, of course, getting infected, and students. I remember last time, students were really, were in a bad mental state. So, and also, institute was not coming out with proper guidelines as to whether the exam is going to happen, not going to happen, nothing. So, aggrieved by this, she was very sad. This girl. So, what she did was she sent a email to the institute, to the president, and she marked a few people, office bearers of the institute, and she sent a mail saying that will the exam happen or not happen? How is it possible if you do like this? With the cases rising, is it safe to do so? Try to do something, some online, exam if possible. It was an impassioned plea. It was out of hurt and confusion. She had sent a mail. And unfortunately, the petitioner and her father also got COVID. So obviously, there was an opt-out scheme which was launched by the CA Institute. So she opted out of the examination and decided to write in January. Right? When she was writing in January, after she wrote the exam, strangely, she got the result on the day of the result. Think about it, guys. I always tell this. CA results.nic.in, you put in your SR, whatever your NRO, SRO, your registration number, and then you hit submit. You write the CAPTCHA code to prove that you're not a robo, first of all, and then you hit, submit. When you hit submit, round comes. After that, if you either is PASS, FIL, it's okay. But this lady got result withheld, and she got a line saying derogatory remarks. My. Derogatory remarks means you have told something against the institute. That's why we are withholding the result. Aggrieved by this, she didn't know what to say. So she sent an apology email saying that please, I'm very sorry. Please, I am ashamed of myself. A lot of tension was going on that time. So kindly do not withhold my result. It's very important for me. Please release my result. At least let me know whether I've passed, failed, whatever it is. This happened, sometime in January, February. So on 26th March, that is very recently, 2021, again, they came out with this petition, result withheld, and the institute declared. Of course, before that, guys, principles of natural justice, as we know, examination committee, there was a hearing. So they said, you please come, we will tell you what you did, what you didn't do. they were always harping on the fact that your email was derogatory. It was against the institute. It was against all those things. So she went and she apologized again there. First of all, via mail, she apologized. Again, there in the committee, she apologized. They said, okay, we'll get back to you with the results. With the results of the hearing, not the results of the, not the exam results of the hearing. She did not get her exam results. She did not get her result of the hearing also. Then she got a letter, mail, whatever, on 26th March saying the results have been withheld because you have adopted unfair means. A direct declaration was done. You have adopted unfair means. Aggrieved by this, on April 21st, 2021, she had filed a writ petition with the High Court. Now the beauty is, this is CA Institute versus the CA student. So the court said, did she pass or fail the CA examination? Whatever, give me the result in a sealed envelope. Now the beauty is, see the beauty. If I open the envelope and if that candidate has failed, is there any point in going ahead with the discussion because she has already failed? Whether she wrote, whether she passed, failed is immaterial because, if she passed, it is material. But if she failed, it's immaterial. What is the point of telling that please declare your result? But the beauty is, the court said, irrespective of this has got nothing to do with the results. This has got to do with the attitude of the institute. So let me, irrespective of whether, the result is pass or fail, let us hear this. So based on the consent of both the parties, this case was heard. Matter was heard irrespective of the result. The moot, some questions thrown. First of all, she said the results have to be declared. Second, have I adopted unfair means? So she requested the court to judge her whether she has adopted unfair means through her email where she has expressed her anguish. If we read the CA regulations, is it anywhere concerned about unfair means? So what is this? Everything, now I will show you. I have marked the important areas in the case law. I have the case law here, right here, guys. So beautiful language. First of all, my pronouns to the judge, beautiful, wonderful. I fell in love with this order, right? The way the person has analyzed, the way the judge has, given the thing. So how to read the law, guys? How to read the petition? You can see this first person is called as the petitioner, right? And the second person is the Institute of Chartered Accountants of India. And of course, since it's the examination committee here, the deputy the secretary examination is also there. So I'll take you through. So for petitioner, Mr. Vikas is the advocate. And for respondents, we have this Manoj Bhandari and Anjay Kuthari. And because of all this, everything is happening through WebEx. It's a online hearing. All right. Now, this came very recently, guys, 2-3 days ago. So 13th May 2021. So I will read out the highlighted parts. You need to understand, as law enthusiasts, we need to know how to read the law. We need to know how to read the judgments, right? And the wonderful language. Ultimately, is it an act which is oppressive? So if you see, the petitioner, a young girl student of 21, has knocked at the doors of the court because of extreme oppressive action. Oppressive action by whom? By the professional body Institute of Chartered Accountants of India, which enjoys a long reputation of setting high standards. So this was a case of like oppression, where they said, okay, just because you're the institute, and does it mean that I do not have a right to speak against you? I know I am waiting hard to come inside the institute and be a chartered accountant, but does it mean that I do not have a right to speak or give my views on certain things? Just because I'm a student, can I speak out? Can't I speak out was the question, right? Now see the language, guys. Although the chronological facts, which I actually have summarized for you, although the chronological facts are handful, means they are quite a lot, but their culmination has been dreadful. Culmination means the final conclusion has been dreadful. Why is it dreadful? Because her results have been withheld, right? Culmination has been dreadful, and concussion thereof, the effect of it, has been doomful. What a language, guys. Think about it. Brilliant, brilliant. This is the reason why we study law, to read such kind of a judgment, right? Culmination has been dreadful, and the concussion thereof, the effect of it, could have been doomful. Means what? If this writ petition was not done, the effect on the entire student community could have been doomful. Means it was ultimately resulting in the entire students' doom. Basically, the students would have had no say in the entire thing. So would have been. So beautiful. So Hats off to the petitioner for filing this writ petition, because of which it has potentially saved the lives of thousands of CA students, right? We will come to it. Then all these other things I will not tell, only put the highlighting points. So because I can discuss this for 3 hours also. That's how much I love this case. But not needed. Okay, just the gist of it is needed. All these things locked down, I already given you the facts of the case. Let's see some of the things. So basically, she sent the mail to 3 people: president, vice president, and some office bearer. Did she send it to examination committee? Very important. Did she send it to examination committee? No. Yeah. So when you download from the Rajasthan High Court, no, this dialogue will come here. So I downloaded in the evening because students are asking me to download from the source itself. So yes, today I downloaded and I just got a chance to read it now. I had a class, so I thought I'll do this video now. In the end, in the email, petitioner highlighted the situation of spread of COVID and she asked for online infrastructure. That's all, online infrastructure. Line by line, I will go. I will connect it with the case which I've already given you, right? Then all these stories I've told you already. Now information that the result has been put on hold because of derogatory remark. She said, I just sent an email. And then she wrote back. She apologized. I told you here, she apologized. Apology mail she sent, after which hearing was done. What was the apology mail? She said she lost her cool because of constant delay due to pandemic. We need to understand, students, guys, you all have gone through, right? I know how much you have endured last year. If I had written that exam during the pandemic, I would not have passed. I'm assuring you that it's not possible. We have strength, weakness, opportunity. This is a threat. You're going to the exam, you don't know what will happen, right? So, safety concerns. And unfortunately, she contracted COVID. Imagine the next week itself. See, she has sent an apology mail. The apology mail has been reproduced verbatim in this order, saying that I'm so sorry for my inappropriate remarks. I completely failed to think about my words. It was probably, if it was hurtful and insensitive, I'm sorry. I acted in a very silly and childlike manner. Childlike means very innocent. So she's begging the institute, which is like a father figure, please forgive me. Please forgive me. If you see, I cannot undo the damage. Correct? And that's what she has told. And it is whatever I've done, I've lost my cool. I'm truly ashamed of myself. Imagine. It's like a small kid going to the father and mother and saying, I'm sorry. Tell me honestly, guys, let's stop here. You think about it. You have sent an email out of anger. Institute tells results withheld. Then I beg you, I'm very sorry, please leave it. As the CA Institute, as the professional accounting body, there is no judgment. Tell me honestly, would you let it go because of the pandemic or whatever situation, or would you take it? Would you take it forward? Institute is the regulatory body, and the office bearers, of course, have to uphold the sanctity of the CA Institute and all the objectives for which it stands for. But this is an ego play. Ego of some of the office bearers, would it bring disrepute to the CA Institute, is what this case is all about. Can CA Institute act as, a body where they suppress the voice of not only the students but also the members, is what this, in that sense of the term, this case assumes extreme significance. It is a must read case for all enthusiasts, especially CA students and members. Let's go ahead. She's telling, please forgive me. I promise that I'll never do it again. Right? That's the thing. Sincerely. So regardless of all this, institute, as I told you what happened, they said alleged resort to unfair means or derogatory remarks. Various emails were exchanged and then final one dialogue came, adopted unfair means. Letter will follow. Letter never came. What did I do? She's asking. Letter will come, don't worry. Hearing happened. Letter will come, letter never came. But final declaration was done against the student who had cleared CA foundation in the first attempt. Final declaration saying that, madam, you have done unfair means. Unfair means. So she said there must be some misunderstanding, what to do, what not to do, whatever it is. I told you it went to the court. Now, court said that I'll go by the merits of the case. Court said, let us read the regulations. I have read the regulations now. I'll open it for you. CA regulations. The only place where disciplinary action can be taken, buddies, is in regulation 41 of the CA regulations. Nobody is above the law, including the CA Institute. We should understand that. See, read it. if a candidate is reported to have misbehaved in a disorderly manner in or near an examination hall, in or near an examination hall. November she didn't write only. January she wrote. This email was sent in November. January she wrote the exam. Whatever, January 7th to whatever it happened, that opt-out scheme. January she wrote. January 7th, whenever the examination held to 20th, whatever it was, did she behave in a disorderly manner? No. Was it in or near the examination hall? No. Or reported to have resorted or attempted to have resorted unfair means for the purpose of passing an exam. Did she do anything to pass the exam? Did she copy? Did she take some chit out? No. And the examination committee may discretion on receipt of a report to that effect and after such investigation as it may deem necessary, take such disciplinary action as it may think fit, provided an opportunity was given before an order adverse to him is passed. Don't tell here him is there, so this will not apply to Miss Risha and all that. General Clauses Act, he includes she. So guys, what I'm trying to tell is this entire thing should have happened in the examination hall. Did it happen in the examination hall? No. When it didn't happen in examination hall, what is the right of the examination committee? Second question. The letter was addressed to the president, vice president and other office bearers. How can examination committee take suo motu cognizance? Examination committee cannot take cognizance. Did I actually write to the examination committee? No. I wrote to the office bearer. Office bearers would have forwarded it to the examination committee. Is that allowed? Next question. And she did not do anything near the examination hall. But can you take that as the final thing? Think about it. Think as lawmakers. You are the judge. What will you decide? I am showing the regulation. You decide. Right? I am not here to pass judgments. I am allowing you to decide. Right? That's the thing. This is the wonderful regulation of 41. Then again in 176 or something they say that the examination committee may pass a review order. Order has already been passed saying that unfair means. So the review committee also can go. So you know what the institute said? According to this 41 to whatever 176, she need not have given a writ petition at all. Writ petition is not maintainable. She should have come to me. Imagine. First you came to me, I said get out. Then my father is there. The review committee. You can come to my father. You cannot go to the High Court. Can CA Institute or anybody ask a person not to sue or not to file a writ petition in contravention of Article 14, 19 and 21 of the Indian Constitution? Equality before the law, freedom of speech and personal liberty. Think about it. I'm just throwing questions at you, right? So now moving on to this. Are you understanding, buddies? I hope you are understanding. Now, all these things, wonderful. Some language we will see. Everything I told you, whatever happened and all those things. So ultimately, matter was heard irrespective of the result. They said, when I say adopted unfair means, is it factually correct? You are actually not at all followed regulation 41. Did she do in and around the examination hall? No. The respondent claimed that she ought not to have raised an issue. Imagine guys, the institute went and told, Your Honor, she should not have raised the issue. She should have come to us, otherwise she would have come to the review committee. But the court said, how can you take suo motu cognizance of the issue? She sent a letter to the office bearer. Examination committee, how did you take cognizance? Where is the independence there? Some office bearer tells you, hey, this student is, creating a problem, you go and take. Are you an independent body or you are only there to fuel the ego of the office bearers is the question. Right? So if you see, in the case, the petitioner's anxiety was only to request the institute to develop an online infrastructure. That's all. Did she do anything? And also her apology letter reflects the enormous pressure and repentance. So they posed a question. She said, I'm ashamed of myself also. So the court asked the ICAI, Sir, what more do you want? What more did you expect? What else did the respondent committee expect of the petition? Is begging for forgiveness. What more do you want? The learned counsel submitted that the ego of the respondent ought to have been satisfied with a mere apology and closed the matter then and there. Institute has failed to show usual grace. Generally, institute shows usual grace. Where is the grace? During the pandemic, students are getting affected, and rather than saying, okay, leave it, Baba, you are now telling, hey, come here, come, let's go to court and get out. Your results withheld. Is that the way? Is what the court said. Correct? It was factually incorrect, is what they said. They also said that this harassment is unbelievable and her image has been tarnished. People are asking, especially, relatives, no, hey, what happened? Result, what happened? Which college are you doing CA? My aunties, uncles, grandfathers, sisters, nephews, niece cleared in first attempt. What is your attempt? What happened? Poor lady, she can't even tell whether I passed or failed. Results withheld. That's the worst, right? So if you see remedy of filing a review before the council against the decision by the examination committee, that's what is not maintainable. All that happened. Now I'll come to the real deal. Earlier also there was one case law which said that a Supreme Court, somebody had put a case saying that institute is unable to hold the examinations because they have not done their homework properly in November. But the ICAI the court was convinced that ICAI has done good job in holding the examination, and they have sufficient infrastructure to hold the examination. So examination happened in November 20 and January 21. So you know what the court said? Not only the initiation of proceedings, but also the manner in which, beautiful manner in which the proceedings is done is without jurisdiction. They told the examination committee, who the hell are you? Where is the jurisdiction for you? And you have gone against the principles of natural justice. I explain in class the concept of PONJ, reasonable opportunity of being heard. This is against the principles of natural justice and what? Capricious, brilliant. What is unpredictable nature? Are you the institute or are you some small kid who's unpredictable? What is his anger? It's arbitrary. It is not following any principle. Arbitrary in nature. These are the meanings of the word. So they actually went and showed the letter also. I want to see, you judge based on this letter. Was it any derogatory? If the exams happen, I will appear. But if the exam number of cases are bound to skyrocket, with all due respect, do you understand the seriousness of the situation? The only way forward is to develop an online infrastructure. So she's like, precaution is better than cure. Please rethink your decisions. That fueled the ego. How can a student talk to me like this? So she said, what happens if a student in my class gives 2 exams and then opts out? What if first 2 days I'm fine, next day I got fever? Then I went for RT-PCR test, it turned out negative, which means it's a fever, a normal fever, normal other viral fever and not COVID. Some genuine questions. I'm not expecting a reply, but please go through this once. Because of this letter, they sent one letter saying that results withheld. Think about it, guys. Just think about it. Then they said the examination committee, you did not send to examination committee. How can examination committee take suo motu cognizance? And they also told maybe that lady could have been more calibrated in her emotional utterance. See the language, guys. She could have been more calibrated in her emotional utterance. But what wrong did she tell? Okay, maybe she could have chosen better words. But what wrong did she ask? The institute's reaction was uncalled for and unwarranted. It is overbearing or high-handedness. High-handedness, looking down upon people. I am great. Ego. Right? So they said the petitioner practically knelt down before the court in subservience. She said, I am very sorry. Subservience. She regretted her action. She used the words truly ashamed of herself. What more do you want? So they said, it's not about restraint. You had no right. You should have abstained from initiating any action against the lady. Instead of burying the hatchet, what did you do? Opened a battlefront against one student. Really, people are dying there and people do not know what to do. And, instead of working towards the betterment of the society, you want to fight with a student who asks a genuine question, right? So they said immediately declare the result of the candidate. Immediately declare. What you have done is you have exceeded the jurisdiction. It is abuse of authority. You have abused your authority, abused the trust which is placed by the students, and you have abused it. Very, very important decision. You cannot give a roadblock for her right of invoking writ jurisdiction. She is governed by 14, 19, 21 of Indian Constitution. Who the hell are you, ICAI, to tell her not to go for writ petition? These are very strong words by the court, mind you friends. Fundamental rights have been infringed and your actions are manifested arbitrary nature. So this entire thing is at the instance of the office bearers, not at the instance of the examination committee. It is the office bearers' ego. Whoever did it, I'm not sure who did it, but whoever did it. And they said, what is your examination committee? If you always listen to the office bearer, it is a mere farce or an eyewash. It is useless to have an examination committee if you cannot work independently. Your alternate remedy of going to the review committee is illusory and an exercise in futility. It's waste. Student will not get anything. It is colorable exercise of power. It showcases, see the very, very strong words, vindictiveness. Vindictive means you want to take revenge against a student. You want to take revenge for her asking a question. Who are you? Right? She said you're called upon to. Basically, I've also told that if you, and one more dialogue they put, you're hereby called upon to refrain from addressing any such communication. If you do so, dire consequences. You're threatening. ICAI threatened that student also. Dire consequences. So they said, what is this attitude? This is really, really bad attitude. It is clearly contrary to the principles of natural justice. And they also said, can you say I'm going to cancel your results if you do it without giving a show cause notice? In the earlier notice, what did they say? Appear before the committee. That's all. Did they give a notice saying that I will withhold your result? No. So a very important case, Gorkha Services versus Government of NCT also has to be checked here. This was another issue with respect to blacklisting. See, the government wanted to blacklist a security agency. So I have to give a show cause notice. In the show cause notice, should I clearly mention that you will be blacklisted and that's why I'm giving show cause? Yes. You just can't give a random notice and say you give your explanation. And when your explanation is not satisfactory, I cannot say I'm blacklisting you. If I want to blacklist an agency, in the show cause notice, I should clearly mention that please give reasons as to why you should not be blacklisted. In this case, the government had not given any such notice. Later, they took a random decision of blacklisting that security agency, went to the Supreme Court. Supreme Court told that government, bro, where? Where did you tell them that you will be blacklisted? You cannot make arbitrary decisions. So this case, they have also told here that I have to also use the law laid down in the Apex Code. Institute should have told the student your results will be withheld. That's why show cause. Institute just said show cause and then arbitrary decision results withheld, and that too for some random reason. Got it? So as it says, it's falling foul of Article 14 of the Constitution. The court feels concerned about the petitioner's plight, who was confronted with just a remark that a result had been cancelled. Imagine you're searching after working so hard, you're searching for your results and it says results withheld. How will you feel? It was and it will have serious repercussions on the emotional or mental equilibrium of a student. Beautiful. Hats off to the court. Beautiful. Right? So again, they have showed all that 41, 57, that is all that, and then inner near examination or whatever we already interpreted, and that too it should only have been between 22nd January to 7th February. Sorry, I said 7th January that time. 22nd January to 7th February. During that time, if she did anything in or near the examination hall, only then she'll be liable. Did she do anything in or near examination hall? No. Then who the hell are you to bring up this case against her? Basically, they are telling your regulations, you are only not following. Some random case just to fuel the ego. and they have given a wonderful thing. They said, "Dear ICAI, you are set up by a separate act of parliament, and that means that you are like a state. Means you are like your own. It's like a country, or basically you're like a state. State means a separate entity which can frame rules. Obviously, institute can frame rules for this for the CAs and the students." So they said, "A state that suppresses freedom of speech and inflicts or imposes extreme punishment just because somebody challenges or criticizes his authority shows the supremacy of the state, and anything that disregards the constitution is not at all called a state. It is oppression at the highest degree." And you know what the best part is? The court said, "Open the envelope. Let's see whether she has passed or failed." This is the most wonderful line, also the most poignant and depressing line. The court finds that the petitioner has passed the CA intermediate examination. Court said, "Immediately give her result. She has passed it. How dare you put her through mental agony?" So friends, this is a wonderful judgment. We should give our hats off, doff our hats to the learned judge, right? Right. The court feels that the quantification of the cost would be guesswork and improper assessment. I don't want to see the cost and all. Whatever you did, you cannot put a value on this. The trauma and agony that you have gone through is unbearable. In cricket, when we see matches and all those things, I remember one Carlos Brathwaite. He won the T20. He hit some 4 sixes, and I think Ian Bishop was the commentator. He said, "Carlos Brathwaite, remember the name." All CA students, my dear friends, you know what they said here? The court. I will tell you why. Remember the name. Remember the name of this case law. The court hastens to add that a professional body like the respondent should introspect, look within, and ensure that its over enthusiasm of professional excellence and setting high standards of discipline should not silence, rather stifle the speech. Brilliant. I know that you want to uphold the highest level of discipline, but that should not suppress the other person from voicing out the opinion. Carlos Brathwaite, remember the name. Please remember the name of Justice Dinesh Mehta, because Justice Dinesh Mehta has given a wonderful judgment upholding Articles 14, 19, 21, and also shown how the ICAI should behave and act well within the powers, because it's a separate state. And also it has told how the office bearers should not fueled by the ego. Why should not they ruin a student's life or even a member's life? With great power comes great responsibility. We would have heard in this, Spider-Man movies and all that. Institute is bestowed with incredible powers, but just because you have those great powers, you cannot do it in an arbitrary fashion. So this is my analysis and my thoughts as well. Wonderful judgment. It is great news for aspirants, CA students and members, and also a reminder to the CA Institute that nobody is above the law, and the office bearers are well within the parameters of ICAI and the law. So this is upholding the true sanctity of our wonderful law, and I hope through the wordings at least you were able to analyze. A lot has been happening since the past few days, you all know that, but this brings about joy, and the fact that that lady has cleared also brings joy. So I wish her all the very best. I personally do not know her, but I wish her all the very best, and I wish all the students very best. You should thank that lady also for applying to the court, because now this has given a huge support. This is a huge support for all our students. On that note, thank you so much for watching. Please share this video if you liked it. Please comment, like, and subscribe for my channel. I'll be releasing videos. It's not just about law, guys. Life is not just about studies. We need to understand much beyond. It's not about your syllabus. You need to do much beyond. So I thank my students for irritating me from morning, from afternoon, whenever this case came. So do it. So I'm happy that I was able to read and could do this for you. I think around 35 minutes of video. Watch it. All the best. Please subscribe, share, and like. Cheers. Love you all. Bye.